We're diving straight into those intense, pulse-pounding historical moments when the absolute highest branches of government clash. We're going to look at the ultimate stress tests of a constitutional democracy, relying entirely on the historical texts, case files, and legal doctrines that actually defined these massive moments in time.
So picture this. In any democratic system with a separation of powers, you've got the executive, the legislative, and the judiciary. But what happens when the executive and the legislature fundamentally disagree on the actual rules of the game itself? Who steps up as the ultimate referee? Well, today, we're exploring how the Supreme Court steps into that exact role to maintain the balance of power, and what happens when that balance is pushed right to the absolute brink.
Here is our roadmap for today. First, the ultimate constitutional referee. Second, the 1973 Constitution crisis. Then, political versus justiciable questions. Fourth, the right to due process. And finally, accountability in high office. Let's jump right in.
Part 1, the ultimate constitutional referee. We're starting our timeline way back in 1936 with the foundational Angara case. The National Assembly and the Electoral Commission were basically locked in this massive turf war over who had jurisdiction over election protests. The court had to step in and set the record straight. Under an American-style system, the written constitution is interpreted and given effect strictly by the judicial department. They aren't just another branch, They have this solemn, inescapable obligation to act as the final boundary setter for the entire government.
And the logic the court used here is honestly fascinating. They brought up this phrase, natura vacuum abhorret, which basically means nature abhors a vacuum. Think about it. If the court cowardly declined to get involved in a massive government controversy, it would create a massive power void. And in government, a void means chaos, competing factions, and a total breakdown of society. So, they are legally bound to step in just to prevent the state framework from completely collapsing.
Moving right along to Part 2, the 1973 Constitution crisis. Okay, the events of January 1973 moved incredibly fast. It was like a whirlwind. A brand new constitution was being pushed through, right? But not by your standard secret ballot election. Instead, it was done by Citizens Assemblies, voting simply by a show of hands. And while the Supreme Court was literally in the middle of hearing petitions to halt this whole process, the president just went ahead and signed Proclamation No. 1102 on January 17th, declaring the new constitution ratified. Suddenly, the highest executive offices were locked in a direct collision course with the Senate and the rules of the 1935 Constitution.
And this brings us to the explosive central issue of the landmark Javellana and Tan cases. You had senators like Vidal Tan and Lorenzo Tañada, alongside everyday citizens like Josue Javellana, directly suing the executive secretary, the Secretary of National Defense, and the rest of the cabinet. Their argument was brilliantly simple. Could a new constitution actually be validated outside the strict, formal election procedures mandated by the existing constitution? They argued that the president had absolutely zero constitutional authority to just arbitrarily create these assemblies to bypass a secure plebiscite.
Now, check out this number, 6. It highlights a super interesting paradox in the final ruling. 6 justices, which, by the way, is a clear majority of the court, actually agreed with the petitioners. They literally concluded that the proposed constitution was not validly ratified according to the law. Yet, because of a highly fractured vote on some related issues, specifically whether the people had just practically accepted the new government anyway, the petitions were ultimately dismissed. In this razor-thin, highly controversial compromise, the final ruling famously stated there was no further judicial obstacle to the new constitution being in full force and effect.
Part 3. Political versus justiciable questions.
To wrap our heads around how courts even navigate high-stakes crises like the ones in 1973, we need to look at their operational limits. Basically, political questions are about the wisdom of a policy, like should the government spend money to build a bridge here or over there? The courts stay completely out of that. That's for voters to decide at the ballot box. But justiciable questions are about strict legality. Did the executive branch even have the constitutional power to build a bridge at all? During the Javellana crisis, the court declared that ratifying a constitution is entirely a matter of legality. It's judiciable, not political, because it tests the absolute outer limits of government power.
All right, Part 4, the right to due process.
Now, zooming out from these giant constitutional crises, these exact same judicial powers also protect everyday citizens and our right to fair play. Let's look at the famous Tanada versus Tuvera case. Imagine being thrown in jail for violating a law that the government literally kept locked inside a desk drawer. No way, right? It's an elementary rule of fair play. Publication in the official gazette or a valid medium is absolutely crucial so that you, the public, have fair notice of what conduct to avoid. You can't be punished for a secret law.
And this whole concept of fair warning totally extends to how laws are actually written too. We saw this in the Estrada case regarding the anti-plunder law.
The court hammered home the vagueness doctrine, which protects citizens from arbitrary power. If a law is written so vaguely that people of common intelligence have to literally guess at its meaning, it's unconstitutional. Why? Because vague laws give police and prosecutors unbridled, unchecked discretion to just target whoever they want based on their own personal interpretation.
The crazy thing is, this standard of fairness is completely universal. It isn't just reserved for high-level politics or criminal trials. In Diokno versus Kazdak, the court applied due process right down to a local labor union dispute. They actually nullified a union election because candidates were disqualified without following the expulsion procedures outlined in their own bylaws. The takeaway here is super clear. You simply cannot bypass procedural rules to deny someone their rights, no matter how small the arena might seem.
Finally, Part 5, Accountability in High Office.
So how are the absolute highest officials kept in check? Well, there's this fascinating legal tool called quo warranto. Usually, if you want to remove a top official, say a chief justice, you have to go through a massive, lengthy political impeachment process for crimes committed while they were in office. But in the highly publicized Serino case, the court dropped a total bombshell. An impeachable officer can actually be ousted entirely outside of impeachment through quo warranto if it's proven they lack the basic constitutional qualifications from the very start of their appointment.
And man, the court applied an incredibly strict standard here. They ruled that failing to consistently file your SALN, that's your statement of assets, liabilities, and net worth, before even joining the court equated to a failure of proven integrity. And what's more, they established a powerful precedent. The state has an imprescriptible right to enforce this, meaning unlike a private citizen who might miss a statute of limitations, the state never, ever waives its right to oust an unqualified official, literally no matter how much time has passed.
So we're going to wrap up this explainer with a thought to just leave you pondering. From that early boundary setting in the Angara case, to the razor-thin, edge-of-your-seat tension of the 1973 Javelena and Tan crisis, all the way to the strict enforcement of due process and integrity, we really see both the absolute fragility and the immense strength of the systems that govern us all. A constitution is literally just ink on paper, without the institutions brave enough to actually uphold it. So how will future generations interpret the rules of the game when the next big crisis arrives? Thank you so much for joining me on this deep dive. Keep asking questions and keep seeking clarity.